City of Naga versus Agna. GR number L-36049. Decision date May 31st, 1976. This case is all about the dispute arises over enforceability of an ordinance requiring the City of Naga to refund taxes, with the Supreme Court ruling in favor of the private respondents and ordering the city to refund the taxes paid and pay interest based on the interpretation of relevant statutes. Let's go to the facts of the case. The facts of the case. This case, City of Naga versus Agna, revolves around the enforceability of Ordinance Number 360, enacted by the City of Naga on June 15, 1970. Ordinance Number 360 altered the existing graduated tax on quarterly gross sales of merchants into percentage tax on gross sales. Private respondents Catalino Agna, Felipe Agna, and Salud Velasco paid taxes under the ordinance for the quarter from July 1, 1970 to September 30, 1970. They subsequently sought a refund, arguing that the ordinance should only take effect in 1971. The city treasurer denied their claim, prompting them to file a complaint with the Court of First Instance of Camarines Sur. The lower court ruled in favor of the respondents, declaring the ordinance enforceable in 1971 and ordering a refund along with interest, attorney's fees, and costs. Petitioners, including City Mayor Vicente P. Cibulo and City Treasurer Joaquin C. Cleope, sought a review, contending that the ordinance took effect in 1970 according to the Section 14 of the City Charter and Section 2 Republic Act No. 2264, a Local Autonomy Act. The issues of the case are whether the Ordinance Number 360 of the City of Naga take effect in 1970 or 1971. The second issue is whether the private respondents entitled to refund to their taxes paid under the ordinance for the quarter of July 1st to September 30, 1970. The ruling of the Supreme Court in these issues, the Supreme Court dismissed the petition, ruling that Ordinance Number 360 took effect in 1971, the year following its approval. Consequently, the private respondents are entitled to refund of the taxes paid for the quarter from July 1st, 1970 to September 30, along with the corresponding interest from filing of the complaint until reimbursement. The court reconciled Section 2309 of the Revised Administrative Code and Section 2 of Republic Act No. 2264 or Local Autonomy Act by distinguishing between ordinances that amend existing municipal license taxes and those that create newly entire taxes. Section 2309 applies to ordinances modifying existing taxes, requiring them to take effect in the next succeeding year after approval. In contrast, Section 2 of the Local Autonomy Act applies to ordinances creating new taxes, which can effect in the quarter following their passage. Since Ordinance Number 360 amended the existing graduated sales tax to percentage tax, it falls under 2309 and should take effect in 1971. The court emphasized the statutes in pari materia should be construed together to form a harmonious system, and the legislative intent must be considered. The decision ensures that taxpayers have adequate time to adjust to new burdens, aligning with the legislative policy embodied in prior statutes. Thank you.